SJC-12180, Commonwealth v. Edwin, Alemany.
Okay, Attorney Crouch, can you hear us?
Yes, I can.
Great. Let's hear from you.
Okay. Good morning. May it please the court. Andrew Crouch on behalf of Edwin Alemany, who appeals from convictions out of the Suffolk County Superior Court. I would like to begin today by addressing the McCoy issue. As this court knows, the motion judge was not the trial judge, so her brief two-sentence decision is due no special deference. This court is in just as good a position to judge the documentary evidence here. But I also want to begin by addressing and clarifying what the standards are that are at play. McCoy makes clear that the issue that we raise here is a serious constitutional one, and that it's addressed through the lens of structural error analysis. Now, the Commonwealth in its brief spends a lot of time focused on ineffective assistance of counsel, and I think McCoy makes clear that's not the relevant standard here. We're not looking at prejudice. We're not trying to frame it as whether or not the defense counsel's decision was manifestly reasonable or unreasonable. Instead, we're actually looking, the determination is whether or not the defendant objected to the pursuit, or 2 points. One, whether the defendant objected to.
So, counsel, can I interrupt you for a second?
Certainly.
It seems to me, we have conflicting affidavits, right? The defendant says they never told me, or I objected to the insanity defense, but appellate counsel spoke to trial counsel, and trial counsel said, yes, we did. He knew about it all along. So why is this enough to get you past, to an evidentiary hearing? Why
Sure.
is the judge below incorrect in saying, I'm not going to believe this self-serving affidavit. I've got another affidavit that says, yes, they did.
Sure, and I'm happy to address that. So the standard here is not that the defendant has to prove, the underlying points of his motion, but just that he has to, cast doubt on the issue. And I think that due to the public nature of these proceedings, we actually have a window, an unusual and unique insight into how this case developed. And we know that from the very earliest days, because it's not just the two, say, competing sets of points of view, but we have a lot of other information that I think comes down to going back to that two-sentence decision. It was part that the motion judge rejected Mr. Alemany's affidavit as self-serving, but also found that there was no corroboration, and I don't think that's supported by the record. And here's the reasons why I think that. First of all, here, that public nature shows us that from the very earliest days, the attorneys who represent him are giving media interviews, and they're talking from jump, before they've even met with him, that they're going to pursue a lack of criminal responsibility defense. And this corroborates what Mr. Alemany says in his affidavit, which is at the very beginning, they're asking me all these questions. They haven't seen any of and objectively, they have not seen or even requested any of the medical records or psych records in the case. This is what they're going for. And in fact, it's not for about a year and a half into the case until they finally actually do that. But I think that you don't have to take my word.
How does that media coverage weigh in terms of whether or not we believe the attorneys who said that, yes, we did discuss it, and his self-serving affidavit that it wasn't discussed, or that he objected?
Sure. I think that it provides some context, and it demonstrates that they have kind of gone into this case from our point of view with blinders on, saying this is the defense we're going to raise, and they're not listening to Mr. Alemany otherwise. So I think it provides context, but I don't think you have to even listen. You don't have to take my affidavit or Mr. Alemany's affidavit. I think it gets a little simpler than that. And I would suggest in the record, halfway through trial during a sidebar, Attorney Denner is speaking with the trial judge here, and this is transcript number 9, page 290. And in that discussion at sidebar, I think it's revelatory. I think it explains, and corroborates Mr. Alemany's point. And this is what happens. Mr. Denner tells the court, I will tell you that this defendant is convincing to me, and it's not affecting my defense at all, but he is convincing to me his inability to grasp anything I'm doing, understand anything I'm doing, and can't quite understand why I'm not attacking everybody viciously, because everyone is lying. He then says, but I'm saying that he's in terms of his, he's in control here. Right. And the court responds, as I can see it, the defendant doesn't grasp the legal strategy of it. He'd rather have you contest it with the witnesses. And Mr. Denner responds, that's what he would like. And then the court responds, but that's why you're the lawyer. I would say that McCoy tells us that that's actually not what the analysis should be here. Instead, what we have is, where Mr. Denner on the record is saying, Mr. Alemany is not happy with me. He wants me to be contesting all of this. He wants me to be cross-examining all of the witnesses. He wants, everybody is lying. That's not consistent with in sort of an acceptance of responsibility or an admission of guilt. And McCoy makes clear that this is, the attorney is a mere assistant in these circumstances, that they have to listen to him. So I'm not saying that this court.
So your evidence is that sidebar and transcript at 9. What do we do with the difference between this case and McCoy? Whereas McCoy was vociferous and consistent in his objection to the strategy of admitting guilt. Here, other than this sidebar, is there anything of the same kind as in McCoy?
And I certainly respect that McCoy may be at the outer reaches, and that may be kind of a gold standard. And certainly as defense counsel, we love to see that sort of thing. But that's just, it's not necessarily how these conversations always happen. They don't always play out in court. So I think the other evidence that we look at.
So let me just alter my question. We don't have the defendant standing up vociferously objecting like we had in McCoy. And we have counsel saying, yeah, we talked to him about this.
Right. And I would suggest this, relating back to the sidebar, which I think does illustrate the goings on in the conversations behind closed doors. But I think beyond that, we have some additional points that I would make. And that is, Mr. Alemany in his affidavit says, Attorney Denner told me that if I refused to go forward with the lack of criminal responsibility defense, he would leave the case. He would just abandon the defense. And Mr. Denner informed me, and I put that in the affidavit. Yeah, that's correct. I told him that, lack of criminal responsibility is the only defense I'm willing to take. And along those lines, Attorney Hubbard, who is not in control of the mental health defense, she's second seat, but she is the one who meets with Mr. Alemany on the regular, whereas Mr. Denner only meets with him the first time, and then in the 22 months until trial, only does it before and after hearings. But Miss Attorney Hubbard is there for those meetings, and she says to me, and that's in my affidavit, that they acknowledge that they did not tell Mr. Alemany that raising a defense of lack of criminal responsibility would require an admission that he killed Amy Lord. And so, there, I think this is corroborating.
Counsel, can I interrupt you on that part?
Certainly.
Because that's the one that I'm struggling with. You have a very clear affidavit where the trial counsel avers that we were very clear that this was the defense that we were going to advance a trial. You even point to an averment that trial counsel was so adamant about pursuing that was the best defense that could be advanced on Mr. Alemany's part, that he said you would withdraw if that were not going to be the defense. For an experienced lawyer like Attorney Denner, was the trial court judge or the motion judge exposed to accept the fact that part and parcel to advancing that defense would not be a discussion that you have to allocate to having killed the person? It's part of the defense that you're not going to be able to advance a lack of criminal responsibility without at the same time saying, I did it.
And I certainly appreciate that as an attorney who has litigated these types of cases, but Mr. Alemany in his position where this is novel to him, no, I don't think it's reasonable for him to have that understanding, and where his counsel doesn't explain that. And I would suggest that, what we're asking for here today is not for this court to allow the motion for a new trial, but to grant a hearing on these back and forth evidentiary issues. And I think one of the things that we'd like to take a look at is indeed, what was the nature of the conversations that happened here? And, I think the implicit thing in Attorney Hubbard's statement is the reason they didn't tell him that is because they knew he didn't want to do that. And I think that's something that can be explored at a hearing.
Well, let me ask you a more refined question then. Assume that there is a hearing and that Attorney Denner or the second chair testifies that we never talked about the fact that you have to admit in the trial, the motion judge just doesn't believe that.
I mean, this is certainly, it is very possible that this goes back to the trial court and this gets resolved in the same way. But I think that we have raised at least the minimum through this sidebar, through the averments in the affidavits, through because the standard here is not one that is so high to jump over. Instead, we just have to raise doubt. And I think that there is doubt through the circumstances and all of the media attention, through the sidebar, through the conversations that, I've had with both of these attorneys, that we at least get to have that.
So why don't we have affidavits from the trial attorneys? I mean, why is it that we take your affidavit and not theirs?
Yes, so the trial attorneys in this case were helpful to an extent, but as happens often, they were not, able to give affidavits beyond this, and they provided.
Well, that's relevant, isn't it? I mean, that's what
Yeah.
the judge was looking at. That's what we're going to look at. We're going to say, well, we don't have an affidavit from them, and that's important. That's a big point here. I think that makes a difference. And looking back at that U.S. Supreme Court case, the dissent in that case went a little too far, I think, but they did raise a point that putting on a defense like this, it's hard not to notice that it includes an admission of guilt.
I think that, yes, and at that point, and what Mr. Alemany says in response to that is he is rocking back, and this is seen on the video that is cited in these news accounts. He is rocking back and forth at counsel table for the majority of the trial because he says he's trying to calm himself down because he's so angry. And Attorney Denner, he says, told him, that the judge would kick him out of court if he spoke up or if he said anything against the lack of criminal responsibility defense. All of this is weighing, we would suggest, on Mr. Alemany's mind while he's trying to make a determination as to whether or not to stand up, as perhaps was done in McCoy. But I don't think the McCoy decision stands for the proposition that to expressly assert oneself, it has to be within the four corners of the walls of a courtroom. I think that we can look at the record otherwise to make a determination as to whether or not there's evidence, especially here where we're not asking for the motion to be allowed. We're simply asking for a hearing on this particular point, for this to come forward to make a determination as to whether or not he expressly made a statement.
Who do you imagine calling at the hearing, by the way?
I think at this sort of hearing, we would probably be looking at, I think, Attorney Nathan had some involvement early on that might have some insights as to how the lack of criminal responsibility defense developed. I think the two defense attorneys, Attorney Denner and
The attorneys you don't like the affidavits from.
Well, the attorneys did not provide affidavits in this case.
So the attorneys who
So yes, I
were
think
less than helpful with they were helpful to an extent, you said. So you
Yes,
think
and-
they'd be
and-
more helpful on the stand?
I don't know if they'd be more helpful or not, but I think it's something that, in this circumstance where this is a key issue and the issue at trial, and where Mr. Alemany, who is the person who is supposed to be in control of his own defense, asserts that I did not want this defense, that he is somebody, even under McCoy, which says, that even if it is the most unreasonable decision in the world that'll lead you straight to the gallows, it is his decision to make. I think that there's sufficient evidence here to bring us and warrant at least an evidentiary inquiry as to what went on here, what were the conversations that happened, and what did Mr. Alemany say.
Can I ask you to address the jury question issue?
Certainly. So in moving to the jury question issue, as this court knows, the crux of the defense at trial was the defendant's mental health and the impact of his alcohol use related to his capacity and criminal responsibility. It was the only live issue at trial. Defense counsel from the beginning through the end conceded guilt at every phase, and the Commonwealth itself does acknowledge that there was some error here. But I think it's important first to
stop you there, because this trial happened in 2015. And so when you say there was some error there, weren't the model instructions in 2015, didn't they have exactly the language that the trial judge used here?
I don't believe they did. And I think the trial judge, here, obviously is someone who was very involved in preparing the future model.
Look at those 2013 and stuff?
I have looked at the 2013, but also we had I believe we had I don't have them directly in front of me,
they were
but
amended in 2018 after the trial, but in
Correct.
2013, I'm pretty sure I looked at them and they were exactly what the trial judge said here.
okay, I'll have to go back and take a look, but my memory was that it
So
did.
assuming that you're wrong and I'm right, if the judge gave the model jury instructions, what was the error?
So if the judge gave the exact model instruction from that time, I would agree that it is not likely that there is an error. But here, my memory is in going through this, and I think the Commonwealth, to my knowledge through its brief, does not suggest that it tracks the model, but instead, the brief there, because this is the thing that I want to clarify. We are looking at subsection 3 of the model. We're not looking at subsection 2 of the lack of criminal responsibility model. Now, the Commonwealth in its brief spends the majority of its time discussing subsection 2, and indeed, basically has the same, beyond that, has, commits a similar error that the trial judge did here by actually misquoting subsection 2. But we're not focused on subsection 2. We're focused on subsection 3 and the transposition of the and the or in that section. And so we would suggest that here, this is not a mere slip of the tongue. Instead, these are instructions that were done in both oral form and, more importantly, went into the jury room to provide the roadmap to guide the jury's deliberation here.
Counsel, what's the prejudice to the defendant? Assuming that you're right, because the Commonwealth also raises the issue that by swapping out that word, the instructions increase the burden to the Commonwealth. So what's the prejudice to the defendant?
Sure. And I would suggest that here, where we had a trial that was 16 days on 17 indictments with hundreds, dozens of witnesses, the prejudice comes in confusing the jury as to the only issue in the case, the only live issue. And that relates to the intoxication and its interplay. And our reading of the transposition of the and the or, and this is influenced a little bit by the Goulet case and its suggestions as to what, the last things that are said to a jury and how that can be problematic here. Our problem is the confusing, the potential to confuse the jury as to when this intoxication part comes in and when it does not come in. And here, the evidence wasn't, overwhelming in terms of its volume alone, where this was a lack of criminal responsibility. For here, even if the evidence was heavily inculpatory, the concern here is, this issue is not, that he perpetrated the offenses and it was overwhelming, but his mental health history and those diagnoses and how the alcohol interplayed. So I think I understand that a reading of it could be that it increases that burden, but I also think that the question is whether it unlocks that question for the jury's consideration. Whereas if you looked at it with the or, it is a circumstance where it seems like it is more applicable, where under the and standard, I think that we have some trouble with that. So for us, the end of the day, this comes down to whether or not the jury would have been confused by this, which is, at that point, the sole and the key issue and left in the case for their consideration. And if the court has any further questions, I'm happy to address them.
Okay, looks like we're all set.
Thank you.
Okay, Attorney Campbell.
Thank you. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. Before I start, I'd like to acknowledge the Lord family, Alexandra Cruz and Kaylee Ballantyne, the victims in this case, as well as John Pappas and Zach Hillman, who are the trial prosecutors. We ask you today to affirm the convictions against the defendant because the evidence at trial overwhelmingly proved that in a span of 20 hours, the defendant terrorized the streets of South Boston, leaving one young woman dead and 2 others injured. If the court has no objection, I'll take the arguments in the order my brother did. The first is to the motion for a new trial issue. I think it's important here. My brother mentioned the legal standard repeatedly, but he left out some key words, which is he kept saying it has to cast doubt on an issue, but it's cast doubt supported by sufficiently credible information. And here the motion judge looked at the information that the defendant provided and deemed that it was not credible.
Can I ask you to address the consistent statement in both his affidavit and counsel's affidavit on appeal that there was no discussion with the defendant as to the admission of the factual killing? Why isn't that enough to raise a sufficient issue, a substantial issue that an evidentiary hearing at the least is required?
So I think it's important. First, I think that you cannot ignore that neither the first seat trial counsel nor the second seat trial counsel provided an affidavit. And I think on that ground, standing alone, it supports the judge in her discretion denying the defendant's motion. So that's the first. The second is, I think if you look at it, it's the second seat counsel, Attorney Hubbard, that makes that assertion, not the first seat counsel, Attorney Denner. So I think that's important as well. And, if you look at the case law, the lack of these, either the first seat or the second seat providing an affidavit are critical to the analysis, I believe. But not only that, if you look at what the trial counsel did have in front of her, and I'd say the transcript, really this assertion comes from
Before you switch
largely.
to that, Ms. Campbell, before you switch to that, could you walk me back on that? Because these McCoy issues are a little different because we've got this conflict between counsel and the defendant. So do we still have always required an affidavit from counsel in this context as opposed to appellate counsel? Because it's, the defense counsel are sort of covering their own approach here a little bit. I'm just wondering if we do the exact, I understand normally we want trial counsel affidavits. I'm just wondering if this McCoy situation is different, or if we required affidavits from trial counsel in these areas as well.
To answer your question directly, I can't think of a case in which in which you do treat it differently, because it is raised in the motion for new trial context. And so that's the rubric and analysis, which I think Judge Roach here appropriately applied in looking at the defendant's motion. But I would say that it is telling, right? Because a lot of the assertions that are made in the affidavit, trial counsel doesn't even, it's not as if there's a partial affidavit from trial counsel or second seat that says some things and not others. Sort of that hybrid model of affidavit is certainly seen in post-conviction motions. So I'd say here, calling upon the Goudreau case and cases that cite that, the conspicuous absence of any affidavit is telling in this instance, and I think it supports Judge Roach's decision below.
You see, because we've written on this too. I think it's Miranda. We had a case in which, again, we were trying to figure out, fighting over what defense counsel had to decide and what the defendant had to decide. And we had a lengthy affidavit from the trial counsel, right, saying, I told him everything, he was informed. We don't have that here though, right?
We don't have that here. And we also don't have, I don't believe, lead counsel making assertions to the contrary, that didn't occur. So, I think when faced with what Judge Roach had in front of her, and given sort of the facts of the case itself and trial counsel's representations to Justice Gaziano during the trial that the defendant had problems with truthfulness and telling the truth, that certainly the decision to discredit the information that was presented in support of this motion is entirely supported.
What about
What is your explanation on that? I'm sorry, Justice Kafker. Go ahead.
No, I think you're asking the same question. Go ahead.
Oh, well, your counsel for the defendant had said, and pointed us to the transcript 9. Can you respond to that? Doesn't that give a little more oomph to his argument that it wasn't discussed with him, the need to plead factual guilt?
Quite candidly, I off the top of my head can't speak more to the context of that sidebar. I don't remember it being pointed out particularly in the defendant's brief or in his motion below. So it's just not something that is necessarily in my mind. I'm happy to provide a 16L letter in which.
No, that's okay. I can read it myself, but let's just assume that it is as suggested by appellate counsel. Attorney Denner suggesting to the judge, my client wants me to pursue this strategy, and the judge says, well, you're the lawyer. Doesn't that present at least a gating issue that would require an evidentiary hearing at that point, where Attorney Hubbard, second seat, is saying, I never discussed with him, it was never discussed with him that he would have to do factual guilt. And then we have Denner on the record discussing with the trial judge saying, hey, my client wants me to fight it tooth and nail all the way. Why not? Why doesn't he get an evidentiary hearing at this point?
Well, I think it's important. I think my answer to that is twofold, not having a specific memory of the sidebar. But the first is, I think it's telling it's on the 9th day of trial when trial counsel stood up in his opening and conceded liability in his opening. There's never any discussion in any of the days previous. It's not brought up.
So I'll grant you it's less than what McCoy did, but isn't it enough to get to a hearing?
And I guess assuming hypothetically not remembering that portion of this transcript, it could be. I think in the context of this case, though, it's important when you look at the context of sort of the behavior that the defendant engaged in during trial, there was, I don't want to make light of it and call it antics, but there were certain behavioral issues that kept occurring, which I think could place this sidebar in context. And I'm not really sure what happens in the middle of a lengthy trial, when this is mentioned sort of at a sidebar incidentally, what that gives rise to the level of. But sort of as a hypothetical proposition, potentially that could give rise to having an evidentiary hearing on that issue. But I would say based on how it was pled before Judge Roach and the affidavits that were before Judge Roach, she certainly did not err or abuse her discretion in declining to hold one. Moving to the jury instruction issue,
Am I wrong, counsel, that these were the jury instructions in 2013? Well, the trial happened in 2015, but I thought the jury instructions in 2013 had the same and/or issue.
So I could have sworn that I looked at the 2013 homicide instructions when I was writing the brief, and that at least as to the portions that are discussed about in the Commonwealth's brief, there was this error.
Okay, so I can look at the instructions myself, but can you tell me, I don't really understand your argument that this heightened the burden on the Commonwealth.
Sure. So if you look at the way that the jury was instructed, if you look at the model, let's start with the model instruction, because I think it demonstrates why it heightens the burden. So if you look at the model instruction and what the Commonwealth has to prove, it sets up a hierarchy of the way that the Commonwealth can disprove the defendant's defense of criminal responsibility. And it lays out 3 separate ways that the Commonwealth could do that, and they only need to do it in one of those ways. And so the jury was instructed, and this is pursuant to the model. The first is by proving that the defendant didn't have a mental defect at all, and that followed the model and was proper. They're then instructed, number 2, that if you find that the defendant did suffer from a mental defect, that he nonetheless retained substantial capacity to appreciate the wrongfulness of or criminality of his conduct, the model says, or to confirm his conduct to the requirements of the law. So under the model, the Commonwealth can disprove criminal responsibility in one of 2 ways. Either showing that he could appreciate the wrongfulness of the criminality of his conduct, or by showing that he could conform his conduct to the requirement of the law. The way that they were instructed was that the Commonwealth had to prove both avenues in order to disprove.
Yeah, but isn't that really under McCool? Isn't that what the Commonwealth does have to prove? It has to prove both.
No.
Okay. So you're saying the Commonwealth can prove that he retained substantial capacity to appreciate the wrongfulness or criminality of his conduct, or to conform his conduct to the requirements of the law?
Yes, that's the way the model instruction reads. And here they were told that the Commonwealth had to prove both in order to disprove criminal responsibility in this way. And the same is true of the next prong, which is number 3. The jury is told that if they find that the defendant lacks substantial capacity to appreciate the wrongfulness or criminality of his conduct and to conform his conduct to the requirements of the law, so that's calling back the prong that they were just instructed of, that the lack of such capacity was solely the result of voluntary intoxication by alcohol or other drugs.
All right, I think you may have those instructions wrong. You might want to check that. But in any event, your position is that taken as a whole, these were 3 different ways that the Commonwealth had to prove beyond reasonable doubt. These, A, if not A, then B, if not B, then C.
Correct.
Is that your point? Okay.
Correct.
All right. And that because there was not an objection to this instruction, which I think is consistent with the instructions in 2013, there is no substantial risk or substantial likelihood of a miscarriage of justice here.
Absolutely, and especially looking at it as a whole, the number of times that the jury was instructed that it was the Commonwealth's burden to disprove criminal responsibility generally.
Can you address the closing argument? Because that seems, actually the opening and the closing, it seems like there was definitely error in both. Why not reverse on those bases?
Certainly.
Just to put a fine point on it, Forever 21, the parents will never do this with her while the defendant's off partying. The parents are fretting and waiting for a call and learning that their daughter is dead.
Yeah, so it's
And why-
forever.
what does it have to do with anything other than atmospherics and pulling on emotion?
So my response as to the forever, it's forever 24. And as to the forever 24, her age was relevant because the defendant engaged in a
Right, but I think the
pattern of
point is that
attacking.
it's forever 24 is,
Sure.
yeah. Mhm.
And certainly, it would be better left unsaid. I think it wasn't objected to, which gives it some insight as to the tone and tenor of it. Mentioned one time in opening statement and one time in the closing statement. More than that, it has to be viewed in light of the instructions to the jury, which they were specifically told both openings and closings were not evidence and weren't to be considered as a substitute for evidence, in light of the instructions that sympathy and bias are to have no part in their deliberation. And also in light of the overwhelming evidence of the defendant's guilt, which is proved in this case through neutral forensic evidence as well as live testimony as
And
well.
what is your view on the corrective instruction given by the trial judge here on the issue of the emotions of the parents and their, plea to consider what the parents felt?
Certainly. So Mrs. Lord did testify at trial, and I would disagree with Your Honor that it was necessarily improper to contrast what her parents were doing with what the defendant was doing, because the defendant's indifference to the victim's suffering, as this was an extreme atrocity case, was relevant to the analysis. But insofar as there was an objection.
But just to stop you there, I mean, you could show indifference just by the partying and the spending of the money. You don't have to contrast that with the parents fretting.
You may not have to. There was an objection to it, which the judge did give a curative instruction. I think it's critical that trial counsel, when he heard what the curative instruction was going to be, did not ask for more or indicate that it was not sufficient to cure the prejudice that he was objecting to. I think given that, the jury is presumed to have followed that in conjunction with the other instructions that I just mentioned, would be sufficient to cure the potential prejudice. Also, considering the evidence of the case itself. I'd say for all those reasons, though, even if this court were to find error, it was not reversible error. If the court has no further questions, I ask that you decline to exercise your power under 33E. This is a case in which the evidence overwhelmingly showed that the defendant murdered Amy Lord. He did so under the very definition of deliberate premeditation, extreme atrocity and cruelty, and while engaged in a number of separate felonies. There's absolutely no basis on this record to reduce the verdict in this case.
Okay, thank you very much.
Thank you.
All persons having anything further to do before the Honorable Justice of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth. At present depart, the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts. Court is adjourned. Thank you. Please remain standing as the justice is exit. Thank you.